This is Dayn Holstrom, Divorce Authority. We're going to be talking about a lot of different subjects in family law. There are some important items that I'm required to share with you so that you understand the limited purpose of my going over all of this information with you. No matter what the specific topic, it's very important for you to understand that this information is not intended as legal advice for any specific person or any specific type or actual case. My sharing this information with you is not designed to create an attorney-client relationship. Everybody's case is different, and nobody's results are the same. Just because we may discuss what happened in some other client's case that may in fact sound similar to yours or some other situation does not suggest that your case or the results would be the same or even similar. The discussion of specific cases are fictionalized and may not be real clients or cases. The purpose of these podcasts is to help you understand the framework of how these issues are decided, provide you a better understanding of the process, and hopefully give you insight as to how you might prepare and conduct yourself and your case to get a better result. There is absolutely no substitute for a consultation or hiring a competent, trained family law attorney, and I encourage you to seek out such an attorney as soon as practical in your case. Divorce Authority is a brand and registered trademark of Holstrom Block & Park, a professional law corporation.
I've been practicing family law for 30 years. I've been certified by the state of California as a family law specialist, so I know a thing or two about divorce. I'm Dayn Holstrom, and I am the Divorce Authority.
Today's podcast is going to be all about support. We're going to be talking about issues of child support and spousal support. And in spousal support, there's two kinds. There's what we call temporary and permanent. They're both calculated very differently and treated very differently. So, support, where do you start? Well, first off, when we're looking at child support and temporary spouse support, it's important to know that the courts of California, they do it calculated based upon software. And that software, there's common names, it's available on the internet. There are some free shareware versions of it. They're not always accurate, but the main ones are called Disso Master and Ex-Spouse, very creative divorce-related names. And what these support software do is they help the court with the complex tax calculations to determine who should pay how much money based on what circumstances. So they have two main factors in the calculation of support. That is income, what does one person make, and what does the other person make, usually parents. I say usually parents because sometimes it's a non-parent, usually parents. And how much time are the children in each parent's home? And so that's called timeshare or custodial timeshare. And that's what's involved in that calculation. So let's start with income. What is income? Well, the stuff you think is income, which is your paycheck. It may be the money you make from self-employment. If you have some kind of a side gig or something like that, that's all income. If you have two jobs, is that income? Yeah, they count it all. What if you have two jobs and you quit one? Well, no, they usually won't count the second job so long as the first job is full-time. Lots of issues like that. And there's a lot of related issues about what happens if and things like that. So let's talk a little bit more about income. So there's W-2 income, which is your paycheck income, and there's self-employment income. Well, how are they different in the program? Well, they're different because W-2 income, you have to pay part of your Social Security, but your employer pays part. So that has a slightly lower tax effect. Self-employment, you pay both ends. Therefore, there's a higher tax effect. So that has a lower value for the calculation of your income. What if you're on disability? If that disability happens to be tax-free, that's counted, but it's counted at a higher rate because there's no tax on it. And these programs have the ability to have a little box or pigeonhole for each and every type of income, because several people may have multiple types of income. They may have a job where they have a W-2 income, they might get a pension or Social Security, and they might also have some tax-free money coming in, and that's all counted. What if you have investments? Yes, counts the income on investments. So all of that calculates as income. Well, going down that income path for just a little bit longer, we now look at what happens if somebody's self-employed and gee whiz, they don't always tell the truth to the IRS or the taxing authority, or to their ex-spouse. Yep, that happens pretty regularly too. And that really comes into two categories. And now we have to get into a cost-benefit analysis. So there are ways to track that and ways to catch that in some cases. Some cases it's very hard and more often expensive to catch it. And then you have to talk to your clients and say, okay, I might be able to prove that extra $500 of income, which will result in a $100 increase in support, but it's probably going to cost you $5,000 to do it. And my hope is by telling the client that, they will say, yeah, that's probably not worth it. And that's probably the most reasonable approach. So the answer is they don't always catch it, but it can be caught. And we're going to talk in a separate compartment in this episode. We're going to talk about high asset and high income earning payers and things like that. So child support in California, once you have this software program, it's based upon what we call a guideline. And the guideline was set up so that if one judge had a set of facts based on income and timeshare, they would issue a support amount that was identical across town or across the state. They had a problem with one person going into one court, one judge, and getting a support award, say of $1,000. Then you go to another court and they get $2,000. And the legislature said, yeah, this does not make sense. It's just serendipity and luck based upon what kind of support award you're going to get. So they made a state guideline. It's been in place for decades now, and that's what's followed. They turned that into a thick book, pre-computers on your phone, and now they've reduced it down to computer software and apps. So it's a lot easier to deal with complicated calculations. And if you put in a 20% timeshare and you put in income of $3,500 W-2 income, I don't care what court you're in, you're going to get the same number. And that's the reason for it. So how does the court know what income to use? Well, it starts from whenever somebody files a request for spousal support or child support with the court, each party is required to file a document called an income and expense declaration, also called or referred as an FL, Family Law Form 150. The FL 150 is a 4-page form created by the Judicial Council of California, and they got a ton of forms. This form is unique because it deals with financial matters. Anytime there's a financial matter before the court, in a family law case, this form is required. First page, biographical. What's your education? What kind of job did you have? How long have you been on this job? Stuff like that. Bottom of that page may also deal to some degree with biographical information. Page 2 deals with your income. What is your income by category, just like we've talked about, whether it's self-employed, W-2. If you have a business, they want you to attach a profit and loss schedule showing your revenue, which is all the money the business brings in, your expenses, and your net profit from the business. That's a requirement that it be included, and they look for a 12-month period. You list all of your income in all of those categories. Page 3 is your expenses. This page tends to confuse a lot of people. And the reason is, and I'll tell you this real candidly, when it comes to child support and to temporary spousal support, the court just doesn't care what your expenses are. And when I say that, and it may be a mild over-characterization, but not much. And the reason is, it doesn't matter if your Ferrari payment is $2,500 a month. They don't care. Because guess what? Supporting your child and your spouse comes first. They don't care that your rent is $1,200, and if you pay this support, you're going to have to live in your car. And I say that not sarcastically. And while they may care, I guess that's a bad phraseology, they're limited discretion with what exceptions they can make by not following the guideline. The court does have some discretion, but in my experience, in that scenario, most judges will not exercise any discretion to deviate from guideline because of a parent's expenses, with a couple of exceptions. Your health insurance, that's deducted from your gross income, from your net income. If you have medical expenses that are not covered by insurance, that also is deducted. So if you have some special needs, and you need, for instance, insulin, and that costs you $200 a month, they're going to take that off your income before they calculate support. Or if you're paying it, they're going to, again, deduct it from your income as a recipient of support. And so those kinds of things they will look at. before they compare the relative incomes. What's important about the expense page then? Well, what's important, it is so common for people who don't have a competent lawyer. And I say that because most people without lawyers will absolutely do it. And most people that have not or less than competent attorneys will also do it. They tend to pump up their expenses in the hope to show the court that they can't afford to pay support or that they need more support. And unfortunately, it has the reverse effect. And the reason is because if you say on page 2, I make $5,000, okay? And then you say on page 3, my expenses are $10,000, and you also list your debt and you show no debt. You show your Macy's card has $200, your Visa card, you owe $1,000. But the judge then looks at that, or your opposing counsel looks at that and says, time out. How are you paying $10,000 of bills on $5,000 of money? Have you got a money tree? Because if you do, that's income. And the reality is they see through that pretty quickly. That can actually backfire on you and cause the court to find a higher level of income because that's what you said. You're paying these bills, they're all current, then they're going to assume you have the money to pay it. Another common faux pas. Raise your hand, I know I can't see you, but raise your hand if you've ever inflated your income a little bit for a loan application or a lease application for a car loan or a house or anything like that. Okay? Well, I see a lot of you have your hands raised. Okay. A lot of people have. Well, guess what we do when we think the other side's not reporting their true income? We subpoena their loan application, their lease application. And guess what? It comes back where you told them that you made $150,000 and now you're telling the court 6 months later you only make $50,000. And there is case law that says the court can use that higher number. Because what happens in that scenario is the court knows you're willing to lie about your income when it suits you. And if that's true, why should I believe you now? So the importance of the expense page is you really know what not to do or how to do it. In the case of a person receiving support, there's a workaround. There are 3 boxes in the expense page if you're asking for support. One is actual expenses. Well, that's self-explanatory. This is what I actually have. One box is estimated, which is similar, but it might be different. Why? Because you may be living at your parents' house for now, but you want to move out, okay? You're maybe in between houses, something like that, so you can put an estimated amount. But the one that I go to for my clients, for recipients, is often proposed needs. Proposed needs for a recipient is based upon that exact scenario where the other spouse cuts them off. So right now they're living in their grandma's basement, but they shouldn't have to do that. And so there you put, what is your housing expense going to be when you get your own place? What is your utilities going to be when you get your own place? And that solves the trap of over-reporting expenses relative to income. You can't really use that if you're the payor, though, if you're in the high-income situation. So again, it's important you have good counsel to make sure you don't make such a simple but just absolutely heartbreaking bad decision and tactic to try to convince the court that you can't afford it. Other ways, tax returns, subpoena bank records, subpoena work paychecks. There's lots of ways. Subpoena is a way that an attorney, without the benefit of the court, can serve a demand on these institutions to get copies of records. It's a common tactic that's used. In high asset or high income cases where we need more sophisticated discovery, besides doing the subpoenas, we may do things like hire what's called a forensic accountant. A forensic accountant will determine what is called in family law controllable cash flow. Controllable cash flow is a combination of every possible access to funds that somebody typically with a business has. And it's the obvious stuff. First off, it's your salary. What happens if the business makes a profit? And you say, I'm not taking that home. The court says, I don't care. You can take it home, so we're calling that income. Okay, well, what about depreciation? I bought a piece of equipment for $100,000 and the law says I can call that as an expense for $100,000 right now. And the court says, yeah, you can do that, but guess what? I'm going to add most or all of that back in because that's not a real cash expense to you. Again, this is a more sophisticated issue, and I'm only covering the surface of these kind of issues. What about the fact that I pay my gym membership and and things like that, and my car are all run through the business. Guess what? The court can reallocate some or all of those expenses to actual income. And that's what controllable cash flow is all about. And that can turn somebody who's claiming $50,000 in income to a couple $100,000 of income very, very quickly. Getting back into the calculation, what is the other factor? Well, the other factor is timeshare. What is timeshare? Timeshare is the amount of time that a child is in each parent's home. I don't want to get into the custody connotations because it's tragic when parents speak in the vernacular of money when they're talking about their kids. So when parents say, I want a 50% timeshare, I want a 20% timeshare, I want them to have a 20% timeshare, what they're really saying is, I want more child support. And when the court hears that, that's what the court's hearing. So on a custody issue, don't talk about percentages or timeshares. Talk about custody arrangements that are in the best interest of the children, number one. Now back to support. Once you've got your custody arrangement, if you have the children half of the time, that is a 50% timeshare, and 50% gets put in the box. The way the support calculation works is that, and I know this is a dry topic, stay with me, the timeshare varies. So the higher the timeshare you have, the more support you will receive if you're the custodial parent or the lower earner, and or the less support you will pay because you have the child with you more of the time. Mathematically, we all know is in the industry, there are 8,760 hours in a year, and that's how the court's supposed to count it. So from a timeshare perspective, long periods of blocks of time are more important than frequent contact with a child. For instance, if you have a child that's only a year old and you may have the child 3 hours a day every single day, guess what? That's going to be less than a total of 1 day of time. And that can be quite a significant time for a child in that area in terms of the quality of the relationship, but it's going to be a very low percentage of timeshare. That's going to increase the support. So what to understand is the amount of child support will vary based upon the income of the parents and the amount of the timeshare. The highest timeshare with the lowest income will receive the highest support, and conversely on the paying. That's how it works. Deductions. I already talked about some of the things the court will deduct. They'll deduct insurance, uncovered health. They'll also deduct things like union dues and what is called mandatory retirement. And that's actually a fairly complicated situation that only exists in most cases for government employees where they are required to pay into a retirement plan, not like a 401k. A common question in cases of support is, what happens if I remarry and my new spouse makes a lot of money? Well, it's a strange way that this works, but it's counterintuitive, meaning that your new spouse's income is not calculated for the purposes of the child support you have with another relationship. However, the more income your new spouse makes, if you file joint taxes with them, that can increase your taxes that you pay. Therefore, your high-income new spouse can actually lower your support in some cases. Not a lot, but it can. And it's just kind of a weird thing that happens in the dynamic of calculating support. What about your house payment? Well, that's the same kind of thing. It's another weird thing that happens is that to the extent your mortgage interest is tax deductible, the higher your house payment, the less support you pay. Wait a second. And to some degree, that law is changing with the changing of the tax laws and mortgage interest deductions and things like that. But that was just another nuance to the support. It's not a big issue. It may be a $10 or $50 issue depending on the circumstances. For child support, there are things called add-ons. Add-ons are, once we do this calculation and we come up with a net amount of money, I'll add one more point there, and that is that if you have more than one child, then the court will stagger the support amount. And so let's say the total amount is $1,500. They weighted in favor of the youngest child. So if for a $1,500 order, it might be that the oldest one is $300, the next one's $500, and the next one's $700. Why is that? If my math added right. And the reason is because, let's say the oldest one's 17. In California, child support stops when the child reaches 18 and is not a full-time high school student residing at home. So what does that mean? That means that they don't graduate until they're 19, then it stops when they're 19, because that's the cap, 19. Unless this is a special needs child, in which case you can get child support throughout adulthood, if the child is incapable of working and supporting themselves. So when that oldest child ages out, as we call it, they simply drop off the amount of support allocated for them, and the remaining amount turns out to be the exact guideline calculation for 2 children instead of 3. That's why they've done that. And so you don't have to go to court every time. I'm going to talk about the topic of how do you change support. It's called modify support in a second, but I want to finish out the add-ons first. So there's mandatory add-ons. Those are things like medical needs for the child. Those are things like, besides medical care, daycare. If a parent needs daycare, either to go to school or to work, then that daycare is shared by both parents. Most commonly, it is shared 50-50. The law doesn't require it. The law just requires that they be shared, but most courts divide it 50-50. Where they might change that is where there's a huge disparity in income. One party might make minimum wage, the other one might make $500,000. When that happens, I could easily see a court saying, yeah, you, the high earner, you're going to pay 80% of the child care, even if it's for mom to go to work or go to school. So that's how that works. Those are mandatory add-ons. Discretionary add-ons are things like tutoring for the child. Many courts will enforce that. It's almost mandatory. What about extracurricular activities? Senior pictures, prom night, homecoming, education-related, club soccer, private lessons, all that. Parents often will go to court to seek to allocate that, and different judges treat that completely differently. Part of it would depend on, hey, did both parents participate in the decision to put the child in soccer? If so, then maybe they should both share the cost. But if one said, I don't want Junior in soccer, and the other parent says, I do, then guess what? They're probably going to be bearing the cost. So those are discretionary and mandatory add-ons, and there's additional ones. Now, how do you change support? How do you modify it? It's everything in family law relating to kids is talked about what's called a change of circumstances. So if and when you have a change in circumstances, that is, what were the circumstances in place when the court made the order, whether it was custody or child support, and we look at that, now what's changed? So if you've got a job and you're making $500,000 and you got laid off, okay? Or if you had a job where you were making $30,000 and the restaurant you worked for got hit by COVID. Answer, that is abso-freaking-lutely a change of circumstance. Now here's the key part that most people don't get and don't do. The court is only allowed to modify the support back in time to when you filed to change it. So guess what? You try to work it out with your spouse and you try for 3, 4, 5 months, you burn through your savings until you're out of money, and 6 months go by and you still haven't got a job, so you go in and you file to modify. Well, that 6 months is burned. You will never get any of that potential increase back. So you go to court, you say, I've lost my job, now I'm collecting unemployment, which in the COVID environment might mean you're making more money. I don't know. But the court will then look at the circumstances in existence at that moment. The court will not speculate that you'll be able to find a job in 2 months. They won't speculate that your unemployment benefits are going to be exhausted in 2 months, therefore they should raise the support automatically. They won't do that. They're not supposed to do that. But what you can do again, you lose your unemployment benefits, you go back in again, and you seek a modification. We talked about before different types of income, and there's non-taxable income and taxable income and stuff like that. Government benefits come in a whole lot of different types. Only one category of governmental income is not considered for child support purposes, and that is need-based payments. If you're getting aid to families, dependent children, AFTC, aka welfare, or other benefits that are based on need, that is not calculated for the purposes of support. All others are. Since unemployment, by way of illustration, is not based on need, it is absolutely counted as income for the purposes of support. You win the lottery, income, okay? You get an inheritance, not income. But if you put the $1 million you just inherited in the bank and you get $100,000 a year in investment income, that is income. We've talked about all kinds of income that can be calculated, but what happens if a parent says, I have no income, whether true or false? Answer: the court has the ability to do something called imputation. In other words, the court will engage in a legal fiction, which is, I'm going to pretend that you are working because I believe you can be working. Well, what's the requirements legally for the court to do that? One, you quit your job on purpose, okay? You get a declaration from your former employer that says she walked in one day and said, F you, I quit. Okay, guess what? They get that declaration, they bring it in, the court's going to probably put you in at the income you had before you were fired from your job. Or, very commonly, and this is the test that's required, the court can impute income through what's called a vocational assessment or your ability to work. And the court can say, you know what? You've got 4 years of college or 6 years of college or 9 years of college, okay? You definitely have an earning capacity is the term of art. So the other side may hire a vocational assessment counselor that will come to court, write a report and says this person could make between $45,000 and $65,000 a year. And the court will then possibly adopt that and put you in for support calculation, whether you're receiving or paying, doesn't matter, and say, we're going to use that calculation for your income even though you're not working. And that has to happen for the parent who says, I don't need to work. My new spouse makes $500,000 a year, so you know what? I'm just going to live the life. And the court says that's not fair. Each party has an absolute duty to support their children mutually. It's really hard once you've been imputed to then have a change of circumstances, because how do you change the fact that you weren't working and now you're not working? So that's a real problem. But that's how they do that. They impute in various circumstances. There are 3 tests the court has to find. 1, there is work out there that you could do. 2, that you're physically, emotionally, etc., able to do the work. 3rd, that to do so is in the best interest of the children. Well, that's the most common one where people blow it on the imputation. So I've seen some fathers, because this is a gender-specific issue, come in because mother is staying at home raising the kids. It's less frequent that the father is the one staying home and taking care of the younger kids, but it fits either way. So a parent is staying home taking care of these very young children. They're a year old or 2 years old, and the other parent's working, and they split. Now what? The working parent says, she should get a job. And the court says, well, time out, or the attorney on behalf of the homebound parent. The reality here is that right now that parent is with these kids all day long. You've got a pretty busy work schedule, so you're not with the kids a lot, during the day at least. Why would it benefit the kids to effectively economically force this parent to go get a job? Because I'm lowering their support as a result of this. Secondarily, why is it better to put these children with a non-parent, i.e. daycare, when they can be with a parent? That makes no sense. All of these issues we've been talking about, imputation and like, they apply across the board in child support, in temporary spousal support, and they will also be applied in permanent spousal support. The only real difference, it's a very significant difference between temporary spousal support and permanent is temporary is what happens when the divorce first starts. Again, the court takes people as they find them, and they say, hey, you're not working right now. I'm not going to typically impute income right now unless we've been separated for a while, number 1. Number 2, you're working, you're not. The kids are this timeshare. We've already done the custody order. I'm not going to change anything right now. We're going to make a temporary order based on this scenario. That's totally separate and apart from somebody going and changing the custody order, which would then result in a change to child support and probably spousal support. And just for reference, the court always calculates child support first, then looks at spousal support with what's left. So the kids' needs are taken care of first. It's important to talk about people who are receiving government benefits. Why? Because when they receive those government benefits, they give up their right to child support to the government. Which means now, If you're the payor, you're not dealing with the mother of your children on child support. You're dealing with the government. And they have a lot more weapons in enforcement and things like that. Briefly on enforcement, they can take away your driver's license, your professional license credential. They can take away a passport. They can intercept your tax refunds. There's a variety of things that the government can do. Sometimes you can do it even without a government in the shoes of the parent through what's called Department of Child Support Services enforcing your case. But they have an arsenal of weapons to collect money. And some are very powerful. They absolutely can deny you a right to work. They take away your contractor's license, your lawyer's license, if you're not paying your support. So that's a little tidbit on enforcement. Anecdotally, I'd like to talk about where can the court deviate in a child support calculation. And my favorite case to talk about in this regard is the case involving John Cryer, the actor who was in 2.5 Men for a long time and part of, I think, was it Breakfast Club and whatever they were way back, my generation, sorry. And that is that he had a child with his wife. It was a marriage, and they weren't married very long. And as the divorce went on, it was finished, and she had the child, I think, 80% of the time, or maybe 50% of the time, and he had the reciprocal. Well, she got into some problems with substance abuse and the like, and in fact, Child Protective Services was called because the kids she had one child with him and one child with somebody else. Anyway, the gist of the story was John Cryer, ended up getting 95% plus of custody of the child, meaning mom had very limited supervised visits with the child. And when that occurred, John Cryer went to court and said, "Hey, Your Honor, child support's supposed to be used for the care of my child. I'm paying her $8,000 a month. She doesn't need that when I have the child." And in this court, and I think a pretty wise and insightful decision, said, you know what, you may be right, but we got a couple problems. Number one, this case was at the time going on in juvenile court, which has a different set of rules for custody. And there's often a transient period where the parent will escalate in how much time. And the court said, you know what happens to her ability to have a home for the child to visit in if I take away that $8,000? The answer is she's going to lose the ability to have a place for the child to visit. So the court said, for now, we're not going to change it. We're going to leave it where it is. And even though guideline would say your support is now only $200 a month, we're going to keep it at $8,000. Well, just to show that no good deed goes unpunished, true to the judge's forecasting, she was correct, and mom ended up getting significant timeshare back. Not all, but significant timeshare back. So Mr. Cryer had at the time a very substantial timeshare. It was perhaps 50% or even more. Mom then comes back and says, since guess what happened when John Cryer, at this point, the series is a hit, he's now making $8 million a year instead of $2 million a year, and she comes back and asks for $90,000 a month in child support. At that point, the court said, no, I'm not going to let you do that. So it's a different tale, but I thought it was a very good story with an insightful judge who really applied the intention of the law of child support as to the best interest of the child, not just an automatic rote calculation. That brings us to the high earner issue, which I'm only going to spend a moment on today because we'll talk about it later with high assets. High earner, the court can deviate from guideline child support, usually downward, when a person is determined to be an extraordinarily high earner. Suffice to say that typically you and me are not extraordinary high earners. I don't care what percent you're in. These are now the people in Southern California that are making probably take home probably somewhere in $10 million a year. $1 million a month might be an extraordinarily high earner. But guess what? $1 million a year, you're not even close. You're not even in the ballpark at being a high earner. They're going to apply guideline. What the court can do, though, is when extraordinary high earner comes in and they say guideline support's going to be $100,000 a month, the court can say, no, I'm not going to do that because the needs of the child will be met at a lower amount. The court's required to go through very specific findings, but they're allowed to do that, and I think most courts will in the right situation. Shifting back to the long-term spousal support, when a divorce is finished, the court will calculate permanent support. Permanent support is a very, very involved calculation by its own. Suffice to say, the court's not allowed to use the calculation. It's done by a variety of factors. There's 14 factors of a particular family code, section 4320, that deals with this. And basically it involves the roles of the parties during the marriage. Did one spouse help the other one get their career? Did they support it? Did they stay home and raise kids? Did they contribute to the education and career path? How long of a marriage? What was the marital standard of living? Did they travel around the world routinely? Were they frugal? Were they frugal because they were creating a huge savings account and therefore contributing to a large retirement expense? The court will look at all of those to come up with an analysis of what permanent support should be. And again, that's going to be a separate episode dealing with all of the complexities of 4320. Otherwise, modifications of spousal support, just like child support, change of circumstance. Could you go to court and seek a modification because your ex-spouse is now living with somebody else? Yes, because the court considers that to be a presumption that they need less support. So that option is available to you. You can also do it if you're making less money, if they're making more money. All of those circumstances exist. Well, that brings us to a close of our episode. It's all about support. You can look forward to more discussing issues of a high asset, high extraordinary high earner support, 4320 factors, and permanent spousal support. But for today, we're going to wind it up. I hope you found this time valuable. I hope you got some meaningful information out of it. If you'd like more information, please download our free ebook at divorceauthority.com and follow us at Divorce Authority. I'm Dayn Holstrom. When I do turns to I don't, turn to Divorce Authority. Thanks for joining us.